welcome to Crime in Court. This is yet another episode of the Canton cover up series because we have been going through many filings from the defense and the Commonwealth. So, this is the Commonwealth versus Karen Reed, and this is episode 116, the Commonwealth's Neurology Expert. So you heard that right. The Commonwealth has put on their witness list this time around for trial 2.0 a neurologist named Dr. Isaac Wolf. So he is a neurologist who is they are trying to have him opine on cause of death for John O'Keefe, and he's not the right kind of medical doctor to be doing so. A neurologist, he's a neurosurgeon actually. So he does surgery on brains. But that does not mean that he can identify cause of death or that he has any kind of forensic experience. None of that. So let's find out a little bit more about him, if I could speak. Please hit the like button as we get started. And this is the defendant's motion to exclude the purported expert testimony of the Commonwealth's proffered witness, Dr. Isaac L. Wolf, and request for Daubert hearing. So now comes the defendant, Karen Reed, and respectfully moves this honorable court to exclude the entirety of the proffered and purported expert testimony of Isaac L. Wolf concerning the medical cause and manner of death of the decedent John O'Keefe and the mechanisms of injury and the conditions of the ground to weather conditions. Remember, they also have an expert, something Gilman, that wants to testify to the hardness or the firmness of the ground, which he's a weather or a meteorologist. So why? That reminds me, somebody that I know made up the word weatherologist, and that is why I almost said that because it's funny to me. He's a meteorologist and he's a weather guy. And he's trying to testify to or they want him probably to testify to the hardness of the ground, which he cannot do. But he can testify to the snow and things like that. The defense is fine with that. All right. So exclusion of the proffered testimony is compelled because it fails each of the two main prongs of the Daubert-Lanigan inquiry, qualifications, and methodology. That is, Dr. Wolf is not qualified to render the opinions he proffers. It is undisputed that he is not a pathologist, nor is he qualified to scientifically measure the material properties of the ground outside of 34 Fairview Road. And he's not a pathologist. Yet, the Commonwealth is seeking to elicit testimony from Dr. Wolf about the decedent's cause of death, the mechanism of injury, and the conditions of the ground due to the weather conditions. It seems like he is going to opine on a lot of things that are out of the scope of his expertise. He thus fails, per se, the crucial qualifications inquiry of the Daubert-Lanigan standard. This failure is not curable. As a neurosurgeon, Dr. Wolf lacks the requisite background, training, and experience necessary to interpret an autopsy report because he is not a qualified or board certified forensic pathologist. Thus, his expertise is limited to treating injuries rather than determining the circumstances under which particular injuries occur. Dr. Wolf is not qualified to testify regarding cause and manner of injury. I don't want you guys, there is another Dr. Wolf, by the way, the ARCA expert Dr. Wolf with an E, that is Daniel Wolf. This is Dr. Isaac Wolf, not to be confused with one another with no E. He's got no E in his name. All right, so this type of opinion is something reserved for a forensic pathologist. In addition, the methodology that he invokes in his report is not reliable. Among other defects in his methodology is replete with errors, as is demonstrated by his failure to acknowledge any contributing medical abnormalities of the decedent and his failure to appropriately address and consider the toxicology and autopsy reports. The failure of either Daubert-Lanigan prong requires exclusion of the proffered testimony of Dr. Wolf, or Dr. Wolf fails both prongs. Sorry, that was a separate sentence. Dr. Wolf fails both prongs of the Daubert-Lanigan uh, standard, and therefore, if you miss one prong, you should be excluded, but he misses both. So here's the argument. The Commonwealth fails to and cannot meet its burden to establish the requisite qualifications of Dr. Wolf to testify regarding cause and manner of death or mechanism of injury. The crucial inquiry in Massachusetts for a Daubert-Lanigan inquiry is whether the proffered witness is qualified to testify regarding the subject matter of his testimony. The subject matter of the proffered testimony of Dr. Wolf and his accompanying report, Dr. Wolf report or report, later uh, referred to, is the medical cause of the injuries and wounds to the head of the decedent as well as the cause of the death. Although Dr. Wolf is a trained neurosurgeon, so that is his background. He's a trained neurosurgeon, which means he performs brain surgery. So he is an intelligent human being at some point. He's a brain surgeon. But the Commonwealth has failed to prove that Dr. Wolf has a reliable basis in his knowledge and experience of his discipline to render an opinion in the field of determining manner and cause of death, identity, pattern injuries, diagnose postmortem hypothermia, and properly read and interpret an autopsy report. So, all of those things he's not an expert in. He shouldn't be able to opine in that. Yes, he may be a medical doctor. That doesn't make him someone who is versed in forensic pathology. And these things, all of which require the expertise of a board certified forensic pathologist to be able to opine on those things. As a neurologist and clinician, Dr. Wolf's background, training, and experience is limited to treatment. He is not a board certified forensic pathologist and has no training or experience in determining mechanisms of injury or the cause and manner of death. The crucial issue in determining whether a witness is qualified to give an expert opinion is whether the witness has sufficient education, training, experience, and familiarity with the subject matter of the testimony. Dr. Wolf's experience and training is limited to providing neurological surgery services, so that is his expertise. Specifically, radiosurgery procedures for inoperable brain tumors. So that is his specialty, apparently, or one of the things he does most frequently. So while Dr. Wolf may be able to provide expertise on how one would treat a brain injury or provide neurological care, he lacks sufficient expertise in conducting the type of postmortem analysis of the cause of injuries and death included in his report. In his report, Dr. Wolf's repeatedly exceeds the scope of his qualifications by reaching opinions on cause of injury, namely, the mechanism of injury was a fall backwards. The head injury was clearly inconsistent with any type of mechanism of injury, such as a bar or hammer or a car hitting him directly. The frozen ground was enough that when Mr. O'Keefe fell backwards, his injuries were sustained. How does he even know that? Like, how can he even opine that the ground was frozen? He's not an expert in that. Ultimately, his death resulted as a combination of the brain injury and his hypothermia. Again, you're not a forensic pathologist, so how do you know that? Here, Dr. Wolf has no experience in diagnosing hypothermia from a dead body, no experience in identifying pattern injuries, and is not trained to read and interpret an autopsy report. In fact, by law, a neurologist is not qualified to issue a death certificate declaring the cause or manner of death of someone who dies of unnatural causes. He is not a forensic pathologist and lacks the appropriate licensing requirements and training necessary to do this properly. I mean, you can't lay it out any clearer than that. A jury should not be permitted to consider such speculative evidence, and Daubert Lanigan requires that this court ensure that Dr. Wolf's conclusions have a reliable factual basis and are limited only to matters precisely within his field of expertise. A forensic pathologist is a physician who has undergone at least 3 years, a physician who has undergone at least 3 years of anatomic pathology residency, then completed 1 year of subspecialty training, and many have additional training and experience within their subspecialties. And that's from some article. Or is that a case? I'm not really sure. All right, so Dr. Wolf has not completed a residency program in anatomical and clinical pathology or any fellowship program in a subspecialty of pathology, which has not received, and he has not received training in other disciplines within the forensic sciences, such as toxicology, and he is not board certified by the American Board of Pathology nor the Osteopathic Board of Pathology. Dr. Wolf ventures well beyond his qualifications as a neurologist and attempts to step into the role of a pathologist and a podologist to opine that the frozen ground was enough that when Mr. O'Keefe fell backwards, his injuries were sustained, and that his death resulted as a combination of the brain injury and his hypothermia. Dr. Wolf is not qualified to testify as to the cause of death, manner of death, mechanism of injury, or the qualities or properties of the ground outside of 34 Fairview Road on the night in question. The court need not reach the other prong methodology of the Daubert Lanigan inquiry to exclude Dr. Wolf because the failure on the qualifications prong alone warrants exclusion of his testimony as to mechanism of injury and cause of manner of death. Even if this court proceeds to the methodology prong of the Daubert Lanigan inquiry, the proposed testimony of Dr. Wolf fails on this prong as well. So he fails, so he has to meet the qualifications and he has to meet the methodology standards. He fails both, is what they're saying. So he shouldn't even be considered. The Commonwealth fails to meet its burden that the methodology of Dr. Wolf is reliable. In addition to whether Dr. Wolf is qualified, this court must also determine that the expert's testimony is sufficiently reliable to reach the jury. As the proponent of the evidence, the Commonwealth must prove by a preponderance of the evidence that Dr. Wolf's methods and processes behind his opinion are scientifically reliable. The proponent of evidence may establish reliability by applying a non exclusive list of Daubert factors, including whether the scientific theory or process has general acceptance in the relevant scientific community, has been or can be subjected to testing, has been subjected to peer review and publication, has an unacceptably high no or potential rate of error, and is governed by recognized standards. So they have to meet all of that. General acceptance in the relevant scientific community is sufficient to establish reliability regardless of other Daubert factors. And this was overruled on other grounds. Okay. If the process or theory underlying an expert's opinion lacks reliability, that opinion should not reach the trier of fact. The trier of fact is the jury. So if that opinion of the expert lacks reliability, doesn't have the methodology or the backing of the relevant scientific community behind it, this guy is not a pathologist, so why is he opining on forensic pathologist type material? It's just very, very interesting. So medical examiners, as expert witnesses, may base their opinions on one, facts personally observed, two, evidence already in the records, and three, facts or data not in evidence that are independently admissible and are a permissible basis for an expert to consider in formulating an opinion. Further, a substitute medical examiner who did not perform the initial autopsy may offer an opinion. So they can get another medical examiner to offer an opinion on the autopsy, on the cause of death, rather, based on the review of the autopsy report prepared by a medical examiner and autopsy photographs, since these are materials which expert medical examiners are accustomed to rely on in basing their expert opinions. However, so they can't so an independent medical examiner can review all of the medical files, police reports, everything, and try to make a determination on the autopsy. However, Dr. Wolf is not a medical examiner. He's not a forensic pathologist, nor is he accustomed to rely on autopsy reports and photographs to draw conclusions. So, why on earth is the Commonwealth even putting this witness forward? It just baffles my mind. First, they put forth a dog behavioral specialist to opine on dog bites. Then they put forth a meteorologist to opine on the firmness of the ground. And now they are putting forth a neurosurgeon to opine on forensic medical examiner type opinions. Are we in the Twilight Zone? I mean, we've been in the Twilight Zone, but I'm just gotta pinch myself. It's just everything is bizarre here. We're in bizarro world. Dr. Wolf claimed that no scientific or technical basis for his opinion. He reviewed various documents and exhibits listed in his report as the basis for his conclusion and offered no explanation of the methodology of his analysis. So he claimed to have read the reports and things, but he didn't explain how he got to his opinions. Moreover, in reaching his opinions and conclusions, he ignored the precise information that must be considered in determining cause and manner of death. Namely, he fails to address or acknowledge the abnormalities present in the decedent and fails to acknowledge any evaluation of the toxicology report, both of which are critical steps that would be considered by anyone trained in forensic pathology in determining cause and mechanism of injury. So he failed to acknowledge the evaluation of the toxicology report and abnormalities that were present on the decedent he did not acknowledge. So there's that. The format of a forensic pathologist's approach differs from a treating physician. A forensic pathologist's investigation begins with death and does not conclude until the results of the autopsy, histology, toxicology, and other ancillary studies have been completed. As a clinical medicine, as in clinical medicine, no finding or laboratory value is interpreted by a pathologist in a vacuum. Particular findings are interpreted in the context of all available pertinent information. Further, the section of the death certificate that is most often misunderstood is the other significant conditions section. Here, Dr. Wolf neglected to acknowledge the entirety of this section in his report, so he just missed a whole other section of things to consider. He missed a whole section. Ultimately, the touchstone of admissibility is reliability. The court must limit its analysis to reliability of the methodology suggested, not the perceived persuasiveness of a proposed expert's conclusions, especially one that Dr. Wolf is not qualified to make and is not supported by evidence of scientific reliability. Whew. This is Alan Jackson and Elizabeth Little. I bet Liza and some of the law clerks wrote this. They do such an excellent job of breaking these down and making it sound like explaining it so that it sounds um, almost like there's no decision but the decision that they are proposing here. So, Dr. Wolf is not a pathologist or a forensic pathologist, and his proffered testimony and methodology is outside the scope of his expertise, thus failing both prongs of the Daubert Lanigan standard. For these reasons, Ms. Reed respectfully requests that the court exclude Dr. Wolf's proposed testimony because the Commonwealth failed to and is unable to satisfy the burden of establishing the proposed testimony meets the requirements set forth in Daubert versus Merrill Dow Farms and Commonwealth versus Lanigan, which is the Daubert slash Lanigan together. So that is signed by the attorneys, and we also have an affidavit from Robert Alessi. Affidavit of Robert Alessi, Esquire, in support of defendant's motions to exclude the purported expert testimony of the Commonwealth's proffered witness, Dr. Isaac L. Wolf, and request for a Daubert Lanigan hearing. My name is Robert Alessi. I am Pro Hoc VJ counsel for defendant Karen Reed. I have reviewed all documents proposed by the Commonwealth in discovery related to the proffered trial testimony of neurological surgeon Dr. Isaac Wolf, which includes his report and his CV or his resume. It's a long resume, but it's a resume. And literature related to determining the manner, cause of death, and mechanism of injury. The Commonwealth has proffered a new expert, Dr. Isaac Wolf, a neurological surgeon with no experience or licensing as a forensic pathologist, to testify regarding the cause and manner of death. After reviewing the materials and assessing other discovery, Dr. Isaac Wolf does not have the training, experience, or expertise that meet the requirements set forth in Daubert, Lanigan, and in Daubert and Lanigan to testify regarding the cause and manner of death or mechanism of injury. Dr. Wolf's report, proffered testimony, and CV failed to establish that he is a qualified expert in forensic pathology, which is necessary in order to reach opinions and conclusions regarding the manner and cause of death and mechanism of injury. A copy of Dr. Wolf's report is attached, and his CV is too. We don't have it. Those things are always filed under seal. We don't get those. Sometimes they file them if it's part of an argument or something, but usually they don't file reports and things from experts. So after reviewing Dr. Wolf's report, his opinions are not scientifically based and are misleading to the jury. So not only does he not have the experience, training, expertise. His opinions aren't scientifically sound, and anything that he would say would be basically lying to the jury. If admitted, these opinions would significantly prejudice Ms. Reed and deny her constitutional right to a fair trial. The Commonwealth has failed to meet its burden to show that Dr. Wolf is qualified to testify on the opinions and conclusions in his report regarding cause and manner of death and or mechanism of injury in such a way that it will assist the trier of fact to understand the evidence or to determine a fact in issue, and that the methodology or theory underlying his testimony is not sufficiently reliable and should allow it to be presented for the jury's consideration. Um, Proponent must establish a sufficient foundation for a judge to determine whether the expert's opinion satisfies the gatekeeper reliability. The defense asserts that Dr. Wolf is not a forensic pathologist and does not have sufficient education, training, experience in determining cause and manner of death and mechanism of injury. In fact, as a clinician, Dr. Wolf lacks the necessary licensing and credentials required to render such an opinion. So it's not that we just don't think he's qualified, he lacks the credentials required. Based on the foregoing, the defense respectfully requests that Dr. Wolf's opinions should be expressly limited to the scope of his expertise, which plainly does not include forensic pathology or the determination of manner and cause of death and mechanism of injury. Indeed, the knowledge of a proposed expert must indicate more than subjective belief or unsupported speculation. Signed under the pains and penalties of perjury, Robert Alessi. So there you have it. They are claiming this guy's not experienced, doesn't have the training. I mean, frankly, he doesn't. He's a neurosurgeon and not a forensic pathologist. Very quickly, I wanted to pull up his website. He works for Miami Neuroscience Center at Larkin, it says. He's Florida based. This is Isaac L. Wolf, MD, FACS, Miami neurosurgeon, world leading authority on stereotat- stereotatic and stereotatic radiosurgery and serves as the medical director at the Miami Neuroscience Center at Larkin Community Hospital, South Florida's leading neuroscience case or care and research facility. I wanted to make another point too because and there's more on here. He's got education, training, graduated with honors from University of Chicago. Interesting. Um Graduated summa cum laude. Okay. So he's smart. Trained at the University of Minnesota. Okay. Over 35 years of experience. American Board of Neurological Surgeons, not forensic pathologists. So that's a big difference there. He's got some career accomplishments here, which I'm not going to read through. Societies, languages. He speaks Spanish also. Very interesting. All right, so that is his website. I just wanted to show you that because I thought it would be interesting, and you guys can go and do some more reading on him. He probably has LinkedIn and all that stuff. You guys can go and look at that on your own. But what was I gonna say? I was gonna say something else, and now I can't remember. Oh, the fact that he brought up in his motion or in that motion, the fact that they brought up the fact that forensic pathologists start from the time of death. Whereas a neurologist, he's trying to save life. He's trying to maintain and save life, right? So they have totally different experiences, training, totally different intentions in their practice. So for them to be like, well, he's a neurosurgeon, he can testify to cause of death. No, that's not how it works. And what's wrong with the pathologist or the medical examiner that they used from last time? I know it didn't help their case very much because she didn't want to change that manner of death to from undetermined to homicide. She didn't want to change that. And that's what Michael Proctor and his little cop buddies were talking about in their text messages about changing the pathologist's determination. And I guess they didn't like her determination, so they're trying to go with a second determination, but it's from someone who doesn't even have forensic pathology experience, so it's not credible, shouldn't be used, and we can all laugh at the Commonwealth for trying to put on these bogus witnesses for these things that they're not qualified for. I think it's hilarious, but also very frustrating for Karen Reed. So it's annoying. But, anyways, that is all I have for you. That catches us up as of this moment that I'm recording, but there's always new filings coming in by the second in this case. So we may have some more videos very shortly to share with you. So thank you guys so much for watching. Please hit the like button on the way out, and I will see you guys in the next one. Take care. Bye now.